you can start.
Okay. Good afternoon, everyone, and welcome to the seminar series of the AI Society. It's an interdisciplinary group on AI, law, and technology, which invites speakers from all over the world to discuss things of common interest. And I'm very pleased to welcome you to a very nice seminar. I'm very honored to have among us the Honorable Judge Richard Sullivan from the Second Circuit of Court of Appeal of the United States of America. The flag that you see behind him is a real flag. It's not something that I purchased over a trip in the United States. Judge Sullivan served as a first instance court judge for a while, then moved upward to the Court of Appeal. And before being a judge in federal courts, he was also an accomplished attorney. A graduate from William & Mary and Yale, he also teaches at Columbia Law School and used to teach also at Fordham Law School. So we have an accomplished scholar with an impressive curriculum and a first-hand expertise of what AI is for when it comes to judicial process. Let me start with a very simple dilemma, and then I give the floor to you, Richard, and thank you so much for being with us. Lawyers, so when lawyers speak of AI in courtrooms, they're always very skeptical. They think that, most of them think that it would be very, very sad if we were to replace judges with robots. So empirical studies suggest that when you face a trial, you're more likely to win if you share the birthday with a judge, or the same regional accent, or if you went to the same school. So there's a sort of implicit bias and unconscious bias that we as human beings have. And so saying no to AI might sound childish, not just wise. So we have a lot of time, we have considerable time today to discuss the pros and cons of using AI in the judicial process. And of course, the United States has been the pioneer both of AI and the judicial process as we know it. So, Honorable Judge Sullivan, floor is yours. Thank you so much. Thank you so much for being with us.
Well, thank you, Andrea. And I'm only sorry that I can't be with you today in Padua. That's a city I have come to love, and I have certainly enjoyed many opportunities to meet with students and to participate in fora like this one. I'm sorry that I can't speak it in Italian. I wish I could. Your English is invariably so good that I'm humbled. But it would be nice if I could speak to you in your language, because you deserve that. But we'll have to proceed in English because it's really the only language that I can communicate in. So I'll tell you a little bit about me. Thank you for that introduction, Professor Pin. But so I'm a federal judge in New York City, which means the national court. New York, the United States is a federal system. We have national courts and we have state courts, as well as municipal courts and lower courts. I'm a federal judge. And what that means is that I am an expert in nothing. Federal judges in the United States are by definition generalists. We handle criminal and civil matters. On the criminal side, we handle cases ranging from things like traditional organized crime, the mafia, you've seen it in the movies, The Godfather, John Gotti, New York's 5 families. We handle cases involving international narcotics trafficking organizations, like Colombian and Mexican cartels. We handle terrorism cases involving Al-Qaeda and ISIS. We have big, massive Ponzi scheme cases. Bernie Madoff was prosecuted in this courthouse, the courthouse where I'm now sitting. We also handle sort of violent street gangs that sell drugs, that engage in acts of violence. We handle white-collar fraud cases, frauds affecting stock prices because of accounting frauds by public companies. We have public corruption, people, elected officials and others who take bribes or are involved in dishonest activities. So we have a range of criminal cases, and that's just the criminal cases. On the civil side, the range is, if anything, even wider. We have cases involving federal statutes, so any case involving a violation of a federal statute or a cause of action under a federal statute will come to my court. That involves things as wide-ranging as securities frauds involving the stock market, employment discrimination cases, people saying they were discriminated on the basis of age or religion, gender, race. We have intellectual property cases. I handle copyright cases, trademark cases, patent cases. I last took chemistry when I was about 16 years old, and yet I am the presiding judge, or have been, involving very complicated patents for for medicines, basically, relating to AIDS drugs and cancer drugs. I have simple wage and hour cases involving people who say that they were not paid minimum wage, often immigrants who've been taken advantage of. I have civil rights cases from prisoners who are asserting inhumane treatment while they're in custody. Disabled people who are asserting claims under the Americans with Disabilities Act because they can't get access to buildings, and the law says they're entitled to that kind of access. Ramps for a wheelchair, counters that are low, bathrooms, restrooms that are accessible. All of these cases involve federal laws, but I also get state cases because in the United States, people who are diverse, somebody from New York can be sued by someone from New Jersey, and they're allowed to come to the national courts rather than a state court, even though the cause of action might be something involving something as simple as a car accident, or a malpractice case involving a doctor, or a product liability case, a contract dispute. These things all find their way into federal courts. So it's an incredibly diverse, never boring docket. And this diversity and this variety, frankly, prevent federal judges from developing subject matter expertise in any single area. There's some court systems where someone is focused on a particular type of case, a judge might be. That's not our system. The strength of this system, I think, is that the diversity and the breadth of cases does make federal judges well suited to assess the judicial system. I have access to and the opportunity to observe such a range of cases with a range of lawyers in all different areas of practice that I'm entitled to a broad overview of how courts work and what courts do well and what they don't do well. So I think that's probably why I am here today. So I've been a judge since 2007, and that was after a 15-year career as a private attorney at a law firm, and then over a decade as a federal prosecutor, prosecuting crimes as the government prosecutor. And then I was, for a couple of years, the general counsel of a Fortune 500 company. So involved the chief legal officer. So I had a diverse background before I came to the bench. My first dozen years as a judge were as a trial judge. That means I was handling cases that began and then would end with a trial or with a resolution by the judge. In the United States, trials are by juries. So what Professor Pin talked about sharing the birthday with a judge, in trials here, generally the judge is not going to be the fact finder. Not always. Parties can dispense with a jury if they'd like, but by and large, juries will make those decisions. Very different from Europe. And certainly Italy, where juries are involved in a small subset of cases. So I'm now an appellate judge. I'm on the United States Court of Appeals. I cover the Second Circuit, which is New York, which is a lot of commercial cases, Connecticut, and Vermont. So I'm now an appellate judge, which is a different job, but it's one that still gives me a perspective and a perch from which to watch the developments in the law, including developments in information technology. So information technology is what it's been about. In 1969, we put a man on the moon. But since then, we have just pioneered in very different kinds of technology that are mostly about communicating here on Earth, often from the distance of just here and across the room. My clerks are here, but as often as not, we're communicating via email or Zoom because of the pandemic. I'm able to communicate with you today through this technology. That's what we've been doing for the last 30 years or more. This past weekend, I was flipping around on TV and I came across a movie called AI, Artificial Intelligence. Steven Spielberg, you know the movie probably. It's from 2001. It's about androids more than what we think of as artificial intelligence. It's kind of like Blade Runner in a lot of ways. I think of it as a sort of a 22nd century Pinocchio about a boy robot who longs to become a real boy. It's a robot with consciousness. Later this same weekend, just flipping around, I came across another movie that's been repeatedly invoked with respect to artificial intelligence. That's the movie Minority Report, also directed by Steven Spielberg. This is the one starring Tom Cruise. And the premise of this movie is that in the future, law enforcement becomes so good at predicting crimes and identifying offenders that they're able to prosecute and punish those people before a crime has even been committed. Now, sounds far-fetched maybe, but we'll talk more about that this afternoon because this is, in many ways, what AI is about. It's about predicting. But I think it's important to nail down the definitions of what we mean by artificial intelligence. When I was a kid in school, I remember learning how to add and subtract. I was 7 years old, and I remember a classmate of mine came in with a calculator. I had never seen a calculator. My parents, nobody had a calculator. This was a 1971 Texas Instruments calculator. And to me, at that time, that seemed like a miracle. This was a machine that could do sums, it could do multiplication, it could do all sorts of things in a second that would take me minutes, maybe longer, and it was always right. That was impressive, but it is not artificial intelligence. Artificial intelligence is more than a calculator, it's more than an algorithm, even a complicated algorithm, performed by a supercomputer that can analyze vast amounts of data. That alone is not artificial intelligence. Insurance companies have been using actuarial data and techniques for years, really for centuries. Computers have enhanced their ability, but it's not artificial intelligence. So artificial intelligence is defined by Webster as, quote, the capability of a machine to imitate human behavior. Well, that's not that helpful a definition, I think. Amazon, which knows a thing or two about artificial intelligence, defines artificial intelligence, or AI, as, quote, the field of computer science dedicated to solving cognitive problems commonly associated with human intelligence, such as learning, problem solving, and pattern recognition. I think that comes closer to what we're talking about. And I guess the last definition that I'll turn to is a judge who has made himself an expert in this space, a judge named Herbert Dixon. He's a retired judge now. But he has described artificial intelligence as combining algorithms and machine learning as a substitute for the human brain to predict, analyze, forecast, and decide. That strikes me as probably the best definition and the one that really is what we're talking about today. So I think artificial intelligence involves a couple of attributes that have to be considered. One is intentionality, the ability to make decisions using data. It's not purely mechanical. It's not predetermined like my calculator. It's capable of choosing between options based on criteria or defining objectives. Intelligence, or the ability to learn, machine learning, AI is able to take data, look at underlying trends, find patterns that support a higher programmed value, and then switch techniques, which then leads to adaptability, the ability of the machine to learn and adapt as it compiles information and makes decisions. So this ability to make decisions based on all information and to continuously improve the quality of decisions is something that a calculator could never do. So that's what we're focused on. A machine that can play chess, a machine that can win at Jeopardy, which is a US, some of you know it, a television show that focuses on trivia across popular culture. A machine that can win at that is clearly different from a calculator or an algorithm used to determine insurance premiums. So today in the world, you're surrounded by Siri and Alexa. I mean, they are now, people I think with COVID talk more to Siri than they do to family members. Bots abound, chat bots that are used to engage with you in customer purchases and in customer complaints. The ability to predict consumer behavior, to predict for you what movies you want to watch that you don't even know about, or what restaurants or clothes you might want to buy. Autonomous vacuums and lawn mowers determine how to clean a room or cut a lawn in ways that are based on machine learning as to what is the most efficient way to achieve that objective. Driverless cars it gets all the talk. The movie Total Recall with Arnold Schwarzenegger, it's from 1990. That's 30 years ago. It was written by the same author who wrote Minority Report, actually, a guy named Philip Dick. But in that movie, there's a scene where this taxi cab is driverless. It's got like a mannequin that is sort of in the driver's seat, but the car is a driverless car. I mean, that is what now is becoming not only imaginable, it's becoming the norm. There was an article in the paper this past weekend about 2 individuals killed in a driverless car. That's going to be the future of liability. So that is AI writ large in society. Bots are used for all kinds of customer cases. Speaking of a car, I had a car, it broke down on the highway. I called the dealership to figure out what was going on, see if they would send me a tow truck. It was after hours. Nobody was there. But they texted me. And so I had several texts before I realized I'm talking to a machine. This is not a person who is able to really respond. It's a machine that is trying to figure out what my problem is and what's the best way to solve it. It did okay. I would have preferred to have a real person. But where AI is used every day and used effectively is in fraud prevention. The first case I had as a judge was Tiffany versus eBay. Tiffany, the retail, luxury goods maker, jewelry and things, was suing eBay, telling eBay, look, you know that all the Tiffany stuff sold on your site, half of it is junk. It's counterfeit, and you're responsible for taking it down. So Tiffany, a very 19th century company, suing eBay, a very 21st century company. And the issue was who's responsible for counterfeits on the site. Tiffany at the time had a paralegal, a young person thinking of going to law school, whose job it was to review all the listings on eBay for Tiffany goods and figure out which ones were a counterfeit, and then to make basically manual requests to have eBay take down the listing. That is all done now by AI software. They're able to scrutinize the listings, take it down. It almost didn't matter who won that case because the software now does it, and it does it cheaply, and it's probably being used by both Tiffany and eBay to ensure that counterfeits are not being sold. Medical diagnoses, using artificial intelligence to make diagnoses or at least limit a range of diagnoses that doctors couldn't do. This technology is going to replace a lot of jobs. I wouldn't want to be a truck driver right now because I think those jobs are going to disappear in 20 years. Customer relations people, I think, are going to be replaced increasingly by bots. It's going to spawn a lot of litigation. But I think the question is artificial intelligence going to replace judges? Is it going to replace lawyers? And that's an interesting question. In my experience, courts and the legal profession have historically been among the least responsive to technical change. They were often the last to computerize and digitize. In the US, where federal judges have life tenure, there's a joke that's often made that the judge's understanding of technology is limited to the state of technology as it existed on his or her last day before taking the bench. Because after that, they don't learn anymore. And there might be some truth to that. When I started on the Court of Appeals in 2018, I was shocked to find out the judges on my court, who work in panels of 3, communicated all via fax. In 2018, faxes. So judges are not always on the cutting edge of technology. And it's not just US judges. We recently had a delegation of Japanese judges and court officials come here to see how we did electronic case filing, basically paperless filing, which we've been doing for about 20 years. In Japan, which I would have thought was way ahead of us on things technological, at least their courts hadn't gotten around to that. They were just in the early stages of doing paperless filings and electronic case filing. So I think lawyers and judges around the world are by nature and training not scientists. They're not interested in science. They often went into law because they weren't good at those things. I think the law also prides itself on being a human profession that can't be quantified or can't be replaced by machines. And to some extent, I think that is true. But at the same time, we can't ignore technology. And I think courts and the legal profession are not ignoring technology. So we are being affected by AI, but it's in fits, it's in spurts. So in the practice of law, and some of you may practice, or at least be familiar with the practice of law, certainly AI has been used for a while in areas like e-discovery and document review. When I was a young lawyer, it was understood at a law firm, I was in my 20s, right out of law school. It was understood that I was going to spend the first couple of years culling through documents. That was going to be a big part of my job, would be to review documents that might be responsive to discovery requests in a litigation, or that might be privileged and therefore not producible. If it were a dispute over an acquisition and the acquiring company said, whoa, you sold us a company that had a main product that was defective. You must have known that when you sold us this. We want damages. That case would be about figuring out whether the acquired company did know what they knew and when they knew it. And that would involve going through dusty boxes in warehouses, usually far from cities. And it involved, having a bunch of Post-its that you could label your documents and explain for later review which ones were responsive, which ones were privileged, and then go through them after successive waves and cuts. It was incredibly time consuming. It was incredibly tedious. It was not very satisfying, but that was a big part of the job. And lawyers made a lot of money off it. Firms did. They charged hundreds of dollars an hour for young lawyers to do that. Now, that is almost exclusively outsourced to non-lawyer providers that use AI to identify responsive documents. It's now estimated that less than 4% of documents are reviewed by human beings. The machines are doing the first cut. So the disputes are generally now over things like search terms for commercially available software that is then going to go through documents. The disputes are just over the terms and the length of time over which the documents will be reviewed. The data suggests clearly that AI document review is more effective, it's more accurate, it is more efficient. That is going to continue to be the case. That piece of practice is basically over. And it's not just documents. It's video, it's audio. In a recent study involving a government entity that was being sued, 33,000 hours of audio recordings were filtered down to 140 hours of relevant recordings, which then would be listened to by the human beings. But the machines culled out 140 relevant hours from 33,000 hours. That is not going away. That is a 95% cost savings, and that has been going on for years. Legal research. I mean, the reality is when I was in law school, I was on the very beginning of this explosion in information technology. But my approach to legal research was usually get a digest, learn an area of law, then review the cases referenced, then go read those cases and analyze those cases to see which other cases they cited and find out cases which cited those cases. And it was a very tedious manual process. That has not been true now for 25 years. Young lawyers now are using Westlaw, natural language programs that allow them to basically say what they want to find, and the machine will figure out the ways to find the relevant cases And will not only do that, it'll digest it. It'll digest it in a form that is intelligible, maybe not eloquent, but certainly understandable. And that is basically the state of technology for legal research. In the US, that's been the case for a long time. It's even true in judges' chambers, where clerks are using Westlaw, Lexis, Google Scholar, and other software to do this AI-assisted research. The writing of legal documents. I mean, I think the reality is that simple documents, wills, retainer agreements, contracts, other legal documents that are not cheap if you ask a lawyer to do them. You can go on LegalZoom now, input what you want and key facts, and it will spit out a legally defensible and serviceable will or other document, power of attorney, healthcare proxy. Those things are certainly reducing the costs of legal expenses for regular people. That's not going away. And so AI technology in that space is making a big difference. Settlement. I was the general counsel of an insurance brokerage. That's a company basically that our clients were Fortune 500 companies for the most part. They had risks all over the world of all sorts of types. We would help them assess risks, and then they would get insurance. Insurance companies, which have reams of data, have used artificial intelligence to generate policies, to determine premiums, to, in the event of disputes, to assess the settlement value of disputes over insurance coverage. Law firms are utilizing these same tools to figure out whether they should bring a suit. They use artificial intelligence to determine the value of a potential suit before it is brought. Hedge funds that are increasingly in the business of litigation funding, at least here, that is a real thing, where they get involved in class action lawsuits because they think there's money to be made. They fund the litigation for a percentage of the award, and they use this AI technology to figure out what are disputes, legal disputes, worth investing in. So that is the state of the law with respect to insurance and law firms and investment firms engaged in the business of dispute resolution. AI is being used increasingly to advise clients by predicting results by courts. Nearly 20 years ago, there was a study that showed that AI software could more accurately predict Supreme Court outcomes than academics could. So maybe AI will replace academics, but they were basically 75% of the time correct, as opposed to 60% for the human experts. This was more recently done with respect to the European Court of Human Rights, and the machine was 80% correct in predicting outcomes by that court, which I would have thought is not that great. I would have thought I could do better, but the reality is that human predictors don't do better. The human predictors, the experts, including academics and practitioners, were about 60% correct, as opposed to 80% by the machine. There is now a growing business of predicting what judges will do. For well-funded clients in cases that involve massive exposure to liability, there are firms that can provide services to let you know what the likelihood of your judge is to rule on a particular motion or to rule at a bench trial if it's a non-jury trial. So there is just this devouring of digital data on me right now. I'm sure of it, that you could figure out how sympathetic I am likely to be to a motion to dismiss a complaint at the early stages of a case involving a claim of securities fraud. That is available to clients who can afford to pay for it. So systems like law that involve precedent, particularly in common law countries where precedent is supposed to govern the way courts decide, computers are very good at learning those rules and then reviewing data and then predicting outcomes. That is something that is not going away because it can be monetized. It can be made commercial. And it is happening, not at all strata of the profession, not for all kinds of clients. This is usually only a certain narrow band of commercial disputes involving a lot of dollars, but it is there. And I imagine that there will be increasing impetus to make data available in things like sentencing or in public law matters, so that others who can't afford to spend thousands or tens of thousands of dollars can utilize this technology. I think that's coming. It's inevitable. That's true also with respect to juries. Juries are harder to predict than judges typically, but juries in certain locations and jurors who have certain demographic characteristics can be predicted. And AI is being used to help assess the outcomes of juries in the Bronx as opposed to Los Angeles. That is inescapably the future or the continued future of the profession. So the courts have typically not gotten into this act, but even courts are experimenting and using AI, at least in some functions. So one area where courts are increasingly using AI is in court administration and filings. Just like my car dealership had a chat bot that was responsible for communicating with me, courts are increasingly using these bots to enhance the experience of litigants, particularly pro se litigants, people who don't have attorneys, but who have a right to bring a case and have a right to access to the courts. These bots are learning to be very effective at educating unsophisticated people in how to access the court, in telling them that the document that they filed is deficient, in telling them, okay, you filed this, the next court appearance or the next deadline will be this, and it will spit out an order that tells the litigant what is next. In Los Angeles, an AI-powered website has been enabling visitors to navigate traffic court, and it's been remarkably effective. In Florida and other courts worldwide, they're using optical character recognition to scan, to route, and to docket documents that are filed online digitally across a range of cases. And what they found is that in the early months of this, the machine made a lot of mistakes and it required human intervention to correct it. That is no longer true. Years later, now these machines are doing a better job than human customer service people. It has allowed clerks' offices to utilize their resources in a different way, to make sure that their human capital is being diverted to higher value functions, and to have simple things that could be done by untrained people done by bots. The US Postal Service has basically not used human mail handlers for routing mail for 20 years. New Jersey courts have basically a system that acts like Siri or Alexa, using natural language processing to direct litigants to particular templates or to particular parts of their website so that they can utilize the courts. This is going to continue. I think more courts are going to be doing this because, frankly, it affects their bottom line. It allows them to do more with less in the way of resources. Another area that is changing radically is court reporting. In the United States, most places, there is a presumption of open courts and open records. And so there is a court reporter transcribing the proceedings. And that report is then available to the public. If they want to know what happened at a sentencing or at a trial, they can get the transcript. The technology utilized until really the present moment has largely been 19th century or early 20th century technology. It is a court reporter using a little box that is a shorthand mechanism. It's mechanical for the most part. They then use software that helps translate it into English. But it is increasingly the case that the human court reporter is going to be removed from this process. And it's going to be done by a machine that has mastered court reporting and the ability to translate sounds into printed language for the purposes of a transcript. That is already happening. It is going to increasingly happen. Language translation. You know, in the US courts, English is the official language of the courts. Everything has to be conducted in English. However, there are so many people who speak other languages that utilize the courts that there is a constant need for foreign language interpreters. Spanish, Chinese being the most prevalent in this location, but any number of others as well. That function has been performed by human beings. They're costly. They're good at what they do. I have great admiration for them. They have been really responsible for the delivery of justice to individuals. but it is something that machines are increasingly able to do, and are doing so because they are cheaper, and eventually they are becoming more accurate. At the very least, they can do the first draft in a way that is very, very solid, with a human being just editing and finishing the product. That is happening. That will continue to happen. That is a function of AI in courts that is, clearly going to be continued. Another area where AI is being used, or it could be used, is a more controversial one, and that's bail and detention hearings. In the United States and most every place, you're presumed innocent when you've been charged with a crime. And so you are generally presumed to be entitled to be released from jail pending your trial. Now, there are exceptions. If a person is a risk of flight, or if a person is a danger to the community, well, then they can be detained. That is a decision made by judges, usually with the assistance of judicial support staff, pretrial services officers, who assess data, make recommendations, and advise the judge. But the judge makes the decision. The reality is that judges have not always been good at this. There was a recent study from Israel that showed that judges in the morning were much more likely to grant bail than judges right before lunch. And that judges then right after lunch were much more likely to grant bail than they were later in the afternoon, suggesting that glucose levels were probably responsible to some extent for bail decisions by judges. Now that's troubling. A machine doesn't have that problem. Machines don't run on glucose, and so they should be consistent over time. And that is, I think, intriguing and makes people think that this is then a tool that should be used to at least assess risk. And so there are tools that have been developed to do this. Federal courts are using something called a pretrial risk assessment tool. Now, I have to admit, this is not really AI. This is really just an algorithm. It's an actuarial tool, but there's no machine learning involved, at least not yet. But it's a tool that basically takes data. It uses an algorithm to then give a score, and based on that score, the pretrial services officer will make a recommendation to the judge. Now, it's not, at least federally, a situation where the pretrial services officer slavishly follows the algorithm. They're free to overrule it. They just use it as an aid. But more than 75% of the time, they are agreeing with the algorithm, and they are making that recommendation to the judge. Now, at least so far, the judge is not told about the algorithm. Neither are the lawyers, which might be good, it might be bad. It might pose problems either way. But thus far, the judge is not being told that. The judge is simply told the recommendation of the court officer who works for the judge. But that is a tool that is increasingly being used, and it could easily be scaled to AI so that AI is able to be dynamic and to learn about patterns, to educate itself and teach itself how to be more efficient at that process. It hasn't happened yet, but it could. Now, these tools are not being used in sentencing federally. A US judge, a federal judge, national court judge, has tremendous discretion in imposing a sentence. They use something called sentencing guidelines, which are basically just a big book that functions as sort of an old-fashioned algorithm, perhaps. It involves scoring based on facts and factual determinations made by a judge with respect to the crime and with respect to the criminal history of the defendant. But in addition to that score, that guidelines score, the judge is also required to consider other factors, including things like the personal history of the defendant, including things like the need to deter or discourage criminal conduct, risk of recidivism, likelihood of rehabilitation. These are things that judges have to consider. Certainly AI can be useful in assessing recidivism. It's hard to assess some of the other factors, but recidivism and perhaps rehabilitation are things that AI could be good at. That's the premise of the movie Minority Report. Thus far, I don't think anybody thinks that these algorithms with machine learning are capable of doing this yet. And since recidivism is only one factor among multiple factors that have to be balanced, there's been no real push for this in federal courts. But state courts have been utilizing there's a system called Compass, which is basically designed to help assess recidivism. The judge ultimately has the decision, but judges are using this data and using this artificial intelligence to inform their decisions in ways that can be troubling. And there are concerns about bias, which we'll talk about in a minute. That's something Professor Pin discussed in his opening remarks. That is a concern. I mean, judges are biased. I mean, they have unconscious biases, they have conscious biases. They have all the failings of human beings that are made of flesh and blood. Machines don't really have biases, but they can be flawed because they are either being affected by programmer bias, that whoever did the programming and the initial algorithms was biased in the programming phase. It could be that the data being analyzed is biased. I mean, a lot of this sentencing data is going to be just crunching numbers and decisions made by judges who are biased. And so to the extent that the judges were biased, that bias may get built into the machine. Or it could be that there's just flawed data. It may be just insufficient data. The data has been collected, digitized, and analyzed in an uneven way. And so that the information is skewed to provide a false sense in the machine as to what the reality is. These are all concerns that can skew results. And these are things that human judges and citizens should be concerned about. But it should also be recognized, of course, though, that the machines might be very effective at identifying biases in judges across cases, among judges across courts, in regions of a country. So these are things that certainly I think AI can be used to at least inform how judges do the sentencing function. And then certainly post-sentencing, we are using more actuarial tools and algorithms, and potentially could be using artificial intelligence to assess how to supervise people who have been released from prison. So as a judge, I will sentence somebody perhaps to 5 years in jail and then 3 years of supervised release by the probation office. They'll be out, they'll be released from prison, they'll be home, living in the community, but they will be supervised. And a high percentage of those supervisees will commit crimes or will violate the terms of their supervision. The supervising authorities, the probation office, is interested in knowing who are the high risk and who are the low risk supervisees. And they have come up with tools that have enabled them to do that. And so they go through this scoring process and they determine who's high risk. And those people get the bulk of the resources available from the probation department. Low risk people get almost no supervision. That was not true 10 years ago, where it was much more even across the board. They have decided to use their resources in a different way. AI is also being utilized and will certainly be utilized in the future to assess how well they supervise. It will allow them to determine through machine learning what types of supervision are most effective at preventing recidivism. And it also will enable them to determine new triggers or new signals of a person who is at risk. It might be that a person, when they started, was not at risk, but in the interim, they've lost a parent, they have lost a job, and they've had a move. And those are stressful things that might highly correlate to return to criminal activity. And those are things that artificial intelligence might be able to identify and predict much better than human probation officers. Social Security Administration is using AI now to review administrative law judge opinions before they get issued. That's not happening in federal courts. I think everybody recognizes it will be a long time before machines are capable of writing common law opinions, opinions in cases in common law courts that will be precedential. I think we're a long way from that. I think I spoke yesterday to my former college roommate who's a high-ranking official at Google. He said, I wouldn't worry about it. I think your job is safe. But for administrative law, for simple types of decisions that are highly constrained by regulatory requirements, AI can be effective at reducing error and reducing error rates. So what the Social Security Administration is concerned about is that they make disability findings if they conclude someone is not disabled, that person has a right to appeal to me, to the Court of Appeals. And if they have not followed the right procedures, it'll get remanded, it'll get kicked back. AI has been very good at identifying where there are deficiencies in the written opinion of an administrative law judge for not following protocols. It's not deciding the ultimate case, but it is telling the administrative law judge, this opinion is not going to cut it. That is something that I think is going to continue, and particularly at lower levels of dispute resolution. I think that will be true in courts like small claims courts, which are usually don't involve lawyers at all, and often are judges who are lawyers. They're not really judges the way I am a judge. I think AI provides a lot of opportunities to resolve those kinds of disputes quickly and cheaply. Family court and other courts are going to continue to use AI to make the court process accessible and to assist probably in dispute resolution. One area where I think AI could be used, but I don't think there's much appetite for it, is in credibility findings. In judge trials like you have, in jury trials like we have, human beings are going to assess the credibility of witnesses. Who's telling the truth? Who's believable? We have had lie detector technology for 50 years. It is not admissible in courts because it's been deemed not reliable. But I have no doubt that the technology now, with AI enhancements, would be capable of determining at a relatively high rate of accuracy whether someone is lying. It could predict the truthfulness or veracity of a witness, probably at least as well as a human fact finder. I don't think there's an appetite to go there. But again, I think it may inform human fact finders about their own limitations and what they look at as being dispositive factors in determining who is a truth teller. I think that kind of technology may be used increasingly in the private sector, in employment decisions, in alternative dispute resolution, where people decide not to go to court, but decide that they're going to allow a more streamlined process that is technology driven to decide these things. I think that is going to be part of the landscape, and people in private litigation will have the freedom in some cases to bypass courts and use arbitrators that are open to this kind of technology for fact finding, for credibility findings. So I think there are opportunities, but there are real concerns. I think Europe, to your credit, I think Europeans, much more than Americans, I think have been skeptical of information technology, have been concerned about privacy interests, and have been concerned about the ethics of this information explosion. And so I think Europe has taken a more proactive approach on this generally than Americans. Americans have sort of viewed technology, I think, very enthusiastically, and sort of only later come around to recognize the concerns that might come from it. So the Council of Europe's Commission for the Efficiency of Justice has developed these ethical principles for the use of AI, which they promulgated in 2018. You may all be familiar with them. Some of you are, I'm sure. But they include 5 different ethical considerations that involve respect for fundamental rights, equal treatment between individuals and groups. In other words, a concern that there's an imbalance in access to AI among different groups in legal process. Data security, the need to ensure that data and algorithms are preserved and kept available so they can be assessed, that the secrets aren't in the machine and not available to human fact finders and judges, that they're transparent, that the methods have to be comprehensible, that there has to be an ability to do a later external audit to make sure that the machine is not functioning imperfectly based on the biases of programmers and the data producers, and that AI must remain under the control of the user. That is, I think, a more controversial one. I think that one of the selling points of AI is that it can do things better than humans, and that it's less efficient the more that it is interrupted by human control. Nonetheless, I think that this is a decision that human beings and societies are going to have to make. And I think, at least for now, the Council of Europe's recommendations are cautious on the side of human control. The US Department of Defense has developed some similar guidelines. I mean, they are accessing tons of information, often beneath the radar so that nobody's really aware of it. And so they have come up with a similar set of ethical considerations that include responsible use, equitable use, traceable, which is, I think, similar to what the Council of Europe is talking about with transparency, reliable, which means auditable, and governable, which really does come back to human control. The ABA, the American Bar Association, has recognized that this is a concern. And so they recently passed a resolution just last year that urges courts and lawyers to address the emerging ethical and legal issues related to artificial intelligence in the practice of law. And this recognizes a need to be aware of bias, of explainability is the term they use, and transparency of automated decisions, of the ethical and beneficial use of AI, and controls and oversight of AI by judges and lawyers who are dealing with vendors and others in the private sector. The model rules of professional conduct, which every lawyer has to adhere to when they take the oath and get admitted to practice, imposes a duty of competence, requiring legal knowledge, skill, thoroughness, and preparation reasonably necessary to the representation of a client. That's a generic rule. It's been around for decades. But the commentary to that rule now includes a reference to artificial intelligence. And it recognizes that a lawyer has to keep abreast of changes in the law and practice, including the benefits and risks associated with relevant technology. So whether courts ultimately embrace artificial intelligence in their operations, the reality is that artificial intelligence is going to become increasingly relevant. Artificial intelligence, if it's not coming into the front door, is going to be coming through the back door of courts. And what do I mean by that? Well, certainly you're going to increasingly see disputes that involve artificial intelligence. That's going to include intellectual property disputes. Who developed this proprietary software? It'll be patent disputes. There'll be trade secrets, theft of trade secret litigation, copyright infringement cases. That's going to require fact finders, whether judges or juries, to at least understand this technology. It's going to require the ability of lawyers and judges to determine how the machine learned, what data it considered, what algorithms it considered at a particular moment in time, and when and how it changed. That's going to be necessary to resolve those disputes. You're also going to see cases that involve liability on things like driverless cars. I mean, when there is an accident between driverless cars or between a driver car and a driverless car, there are going to be disputes about who's at fault. And that is going to introduce all kinds of data because the driverless car has explosive amounts of data. And it is going to be questioned and just need to be understood by a fact finder whether it's reliable. And also, if there's liability, who is responsible? Is it the programmer? Is it some other person in the line of the development of this technology? I think that will be true for driverless car cases. It'll be true for misdiagnoses of disease, where AI is used to diagnose ailments. There will be malpractice cases, and doctors are going to sue or implead the software provider that gave them access to the AI that turned out to be flawed, perhaps. That'll be true with just calculations of damages or premium costs. People are going to be looking for deep pockets to sue, and the programmer is going to be in the sights of litigants. This is also going to be true with respect to expert testimony. Even in criminal cases, there is going to be now testimony about DNA, and increasingly DNA experts are using AI technology. There's going to be a need to understand that technology. In the US, at least, a judge plays a gatekeeping role before it goes to the jury. And the judge has to make sure that this opinion, testimony from an individual witness is based on reliable and sufficient principles that can make the opinion a reliable source of information for the fact finder. That is going to require a person to be able to explain what the machine did. That is something that is not necessarily essential to developing AI, but for court cases, it's going to be crucial. And I think the question is going to be what happens when a developer doesn't build in auditability and transparency into their programs. And there is now a question about liability or a question about reliability. And there is not a human witness who can testify to that reliability. That is likely going to keep that evidence out, and it's going to have results that will affect liability for individuals, and potentially it'll have an effect on the bottom line of litigants. So I think these things are going to happen. Courts are going to have to be aware of it, and they're going to have to adapt, which is not something that judges have typically been good at. So the model rules of judicial conduct in the United States says a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary. That is going to require knowledge and understanding of these new technologies, because a court that is not capable of assessing these technologies is going to cede its independence, its integrity, and its impartiality. And I think that is going to be a debate that keeps us busy for the next several decades. So I'll stop there, because I'm sure there are a lot of questions, and I'm sure there are people who know this space better than I do, because, as I said, I'm a generalist and I don't know anything. I'm just a judge. But I do think it's a dialogue that's worth having, and it's a dialogue that's worth having across cultures, across continents, among academics and judges and practitioners. So thanks for having me, and I'm looking forward to this conversation.
Thank you so much, Judge Sullivan. It was a very, very eyesight perspective of what's going on in the field of AI and the relationship between AI and adjudicating. And there are a lot of nuances and a lot of perspectives you're opening up by just mentioning that. Thank you so much. Let's see whether we have any questions. Otherwise, I have plenty of, but I can find other ways to ask them. Let's see whether there's anyone here who's willing to participate in the conversation. So I see both students and okay. We have Professor Eric Longo from the University of Florence willing to speak. I think Eric, I think you can turn on the camera and ask.
Thank you. Good evening. Thank you, Justice Sullivan. I don't want to steal the floor to students, but I have two very quick questions. The first one is that, what Justice Sullivan, and thank you for your very complete description. In a few minutes, you describe everything I think is a solution for justice in the United States. Probably in your position, you are better suited to understand this. I have two questions. Probably these are broad and I can say questions on different topics. The first one is I should say the relationship with private power, because when you speak about AI, you mentioned one very big corporation that uses AI for search engine, Google, but we can mention Facebook and we can mention IBM and another corporation. But the problem is that many times you have procurement for this large corporation, and you use in terms of the government, the federal government or the state governments, they use procurement to ask this big corporation to do things for them, big corporation or small corporation doing this. So, which is, according to you, one thing that in the procurement of AI for justice you need? I think I can say probably this is one point of the question important for when you say I use AI. Can you trust that AI? Can you be confident that AI works well? The first question, and I'm sorry for being so. The second question is about I would say this is very, very, very quick. Do you think that our judges, but you were saying something to this, are judges well equipped to use AI? Because, as you said, there are a lot of areas where you use AI, and these are areas very broad. You talk about constraint and regulatory requirements, dispute resolution, lie detectors, which is something, according to me, really probably a little bit dangerous for some reason. And I have the last question is about Europe. You said at the end Europe and the United States. So are you, because last week Europe released a sort of communication, European Commission released a communication about the use of AI also in justice in many areas. And they try to use something that you referred to another question about high risk artificial intelligence use. So in this sense, the use of artificial intelligence in justice is very, very risky in terms of, you mentioned a lot of, I can say a lot of things that can make judging more effective, the counsel, and you substitute counsel with the AI. But I think, do you think that there is also a risky business that has to be managed before using AI, also in connection with rules? Because probably our approach, our European approach, is much more, I could say, much more narrow than your approach in terms of we are more Luddist in this sense. No, we are more not so open to artificial intelligence. But do you think that this could be a way to push regulators to better rule and regulate this kind of AI? Thank you, and really thank you for your wonderful lecture.
Well, thank you, Eric. I mean, I know Eric a long time, so he's a good friend along with Professor Pin. So it's nice to see familiar faces. So with respect to, I think, the procurement point, I mean, I think, so generally, I mean, courts utilize, they use procurement, they use commercial providers to help them develop techniques. They also, develop some of their own. I mean, some of the algorithmic things I talked about for risk assessment, those were developed by the Administrative Office of U.S. Courts with outside consultants, but it wasn't an off-the-shelf kind of thing. This Compass is a sentencing AI system that was very controversial. It's been used by states. That was a commercially developed system. The federal courts have been developing their own with consultants, and so far has been quite reluctant to fully embrace AI as a predictor of either flight, dangerousness, or future criminality. They've been very reluctant to do that. And I think probably with good reason, because I think that it is unclear whether the AI is necessarily an improvement over judges. So in terms of the Facebook and Google, I think that's a conversation about whether or not these are industries that need to be broken up. I think that there's been increasing talk in the US Congress and elsewhere about whether or not these companies are sort of like utilities that need to be broken up the way phone companies and other monopolies were in the 20th century. That, I think, will have an impact on some of these things we talked about today. But I think not as much for courts, because I think courts are not huge consumers of those services, at least not yet. But I think the more interesting question is the second one. Are judges well equipped to use AI, and are there risks in using AI? Of course there are. I think, though, of course, there are risks in not using AI. Judges using, just pens and paper are often extremely biased, and they are not able to be assessed in meaningful ways because nobody's able to scrutinize them. That is starting to change because private vendors are now taking a look at everything that judges do. When I sentence somebody, I have to send that information to Washington, to the Department of Justice and the United States Sentencing Commission, and they keep track. But a litigant doesn't have access to that. They can't say, I have a sentencing in front of Sullivan. I want to figure out what he does. and how he sentences people who are under 25, how he sentences people for particular types of crimes. That's not available. The private sector is starting to fill that gap just because they now get access to information and they have the ability to just devour it and to use AI technologies to learn from it and then to predict what I'm likely to do. I think that's going to continue, and whether it's sanctioned by the courts or whether it's just done by the private sector, I think judges are going to learn about it because litigants are going to probably tap into it at least some of the time. And they are going to tailor their arguments to things that they think will work for me, or they will confront me to say, by the way, judge, you sentence everybody to jail who's charged with this kind of crime, and that's not what they're doing elsewhere in the judiciary. I think that can be an opportunity to help judges like me recognize where they may have unconscious biases, or where they have at least made decisions that are out of step with other judges. So I think this is going to be a dialogue that goes on for a long time, Eric. I think by and large, most countries, including the United States, will be skeptical about ceding decision-making to smart machines. I do think that different countries will have more interest in allowing smart machines to have input in that process. I think China is apparently doing that already, at least if you believe what you read coming out of China. And there are some other countries that are also much more open to this. I think some of the states in the United States are much more interested in this, not having the machine decide the sentence, but having the machine inform the decision maker in ways that are measurable. And I think that's probably going to continue, and we will, through trial and error, come up with more reliable systems that gain the confidence of courts. I think that will be the process that plays out over the next 10 years. So I don't know, those are thoughts, but I'd be curious if you have a different view.
Thank you very much. Let's see if we have more questions. I think there's someone. Okay, let me introduce you to Eliza Spieler, who teaches law and data in our university and deals with AI and law, has been dealing with that for years now. So the floor is yours, Eliza.
So Eliza is an expert, so I want to hear from an expert. Good.
I'm not sure to be an expert, but I have a question for you. First of all, I joined Eric. Thank you so much for your lecture. And my question concerns the role of design, technological design, in the elaboration of new form of regulation and in the enforcement of existing law and regulation. Because we saw how AI can replace human, but at the same time has even a regulatory value, has all the technologies that we use. So this is the topic of my question that I hope is not too much generic. Thank you so much.
Well, I think you really put your finger on it. I think it is going to require agencies and legislators who write the laws and write the regulations are going to need to understand this area of technology. And they're going to need to have consultants and access to, I think they're going to have access to the leaders in the field, academics and people in the private sector who understand this. They're also going to have access to ethicists. I think that is going to have to be a part of any process of writing regulations and writing statutes. That traditionally has not been part of that process. I think, if you looked at the great age of regulation in the United States, it sort of was with the New Deal. An explosion in regulatory agencies and regulations that effectively, became the way that a modern society and government legislate. The legislation was general, the regulations were specific, but not much focus on technical knowledge of systems and very little focus on ethics. And I think that that's what's new about the 21st century technologies. Is I think we're going to need to have that sort of expertise brought into the process. So in the US, and I'm sure in Italy as well, there are, when there's a new regulation, it goes out for public comment. There's opportunities for people to respond. And that process, I think, is going to have to increasingly seek out the views of the experts in the field of technology and in the field of ethics, technological ethics, because I think these questions are too big to leave to bureaucrats. I think the bureaucrats and judges, who are just a different kind of bureaucrat, are not necessarily up to this. They need to be educated. I think the academy has a huge role to play. So, I think that you're starting to see a lot of articles on this in journals. I think there need to be more. And I think that judges who have gotten out of practice, I think, in terms of reading journals, judges don't typically read law journals the way they did probably 50 years ago. I think they need to in certain areas, and this is one. So I think that's a contribution that you can make, Eliza, and so can the other academics who are on this Zoom call, because I think your scholarship is going to be more relevant than ever. There's this window of opportunity to educate judges and administrators and legislators about what is the right balance, because it's really about balancing, right? And I think those are decisions that are going to get made and that can be made wrong. So, so I think you need to stay in there and keep us honest, and that means confronting us with data and with strong arguments.
Thank you.
Thank you, Richard. There's a question that somebody left on chat box. Maybe you can read it. I'll read it out aloud for everyone. So it's from Laura Gaspari. I have a question for Judge Sullivan. Considering the fact that in America you have jury trials, do you think citizens would more likely rely on a jury made up of different people that may be affected by different kind of things or emotions, as you previously said, or on AI machines that supposedly should be objective? Would people trust a machine more than a group of people? Thank you. That's a very good question.
Yeah, it's an excellent question. I mean, I think I would break it down even more than that. So in the United States, a person has a right to a jury trial most of the time in civil cases and criminal cases. But they can waive that right if they want. So they could give that up and say, I want to just have a judge trial, a bench trial with just the judge. And that happened. My Tiffany versus eBay, that was a bench trial. Those were very sophisticated parties. They've said to themselves, we don't want this going to a jury. Let's have the judge be able to decide this. The judge will be able to follow the arguments, follow the evidence, and give us a more rational decision. And that's always permissible. But most of the time, litigants don't choose bench trials. They typically choose jury trials. And as long as one party wants a jury trial, there will be a jury trial. I think that will probably continue for criminal cases for the most part. It will continue, I think, for personal injury cases and most commercial cases. I think what you have seen is a lot of very sophisticated players have left the court system altogether. They have gone to alternative dispute resolution. They've gone to arbitrators, private judges. They've taken juries out of it. They've limited the amount of discovery, and they have allowed themselves to pick their arbitrators, usually within limits. I could imagine that certain litigants will choose to have either machines or machines assisting arbitrators, much more than would be true in courts, and certainly much more than would be true with juries. So I think certain types of disputes and certain types of litigants will find this attractive. And I imagine some of the big tech companies will be perhaps interested in going this route, in using AI-assisted alternative dispute resolution. I think some of them are probably doing that already. And I think certainly at the settlement stage, I think that AI is increasingly being used in alternative dispute resolution scenarios where the arbitrator will say, look, guys, we can have this, I can decide this on the merits, but my review of the AI reflects that the difference between you is really this much and this much. So why can't we settle this? I think that is also going to be an area where the machines are used quite a bit. I think we're still a long way away, though, from machines replacing human fact finders. I don't think most people want it, I don't think most people have that kind of confidence in it. And I think they want to have some ability to override the machine. So I think maybe that will change over time. But I think for most disputes, which involve, fairly sophisticated facts and law and decisions, I think most people don't want to just cede it to a machine. I'd be curious if you think that's wrong, or if there are some people who have more confidence in machines than juries or judges.
Thank you. I know of a story. I know of a sort of parallel in the field of public health. So many people were interviewed, and they told that they would rather have an AI device to tell them what they have in their body, or actually to detect what they have in their body, but a human doctor to let them know what they have. So it's one thing to detect us if there's something. There's another thing to share this news with the patient. So there's a probably human component, which is I think important. I don't know.
Well, there's certainly a human. I mean, I talk about the human component of medical care, at least in the United States, which we sue everybody, right? That's what we do. But there is data that shows that doctors with good bedside manner, doctors who explain things, who are patient and take time to talk to their clients, get sued much less than other doctors. And it doesn't necessarily have to do with the quality of their decision or advice. It often is that litigants are reluctant to sue doctors toward whom they are favorably disposed, who they viewed as kind and patient and generous with their time. So I don't think that's ever going to be eliminated from the process. Insurance companies might be different, however. So, insurance companies have used actuarial tables forever, and they are certainly using AI to assess risk and to assess whether they should litigate and how they should litigate. And I could imagine that for a range of cases that involve insurance companies suing each other, the nominal litigants are an individual and a company or two companies, but it's really two insurance companies. My hunch is that they may be very willing to allow machines to decide those disputes, as long as they can agree on the machine or agree on the software. And in many cases, they may. Since an awful lot of litigation is driven by insurers, I would expect that's going to happen. It won't be obvious because those will go down as settlements. And settlements are not typically public and transparent, but it will certainly resolve an awful lot of litigation or potential litigation. I think that's one area where you are going to see machines carry a lot of freight.
Thank you so much. Let's see whether there are any questions. Otherwise, I will have one more. Okay. If you don't mind, I'll ask you a question. So the picture you painted, of course, does not foresee an easy replacements of human judges with AI judges, but certainly a combination of the two with judges being held by AI devices. I was wondering whether, as you said, the impact of AI on the judicial process may be worsen social and economic imbalances, and may push human judges to over-rely on AI-based tools. Let me just make a couple of examples. One will be the scenario within which you have law firms who are affluent and can be paid for by affluent members of society, and they can rely on AI tools. These might not be available to everyone. So those who are worse off are likely to have not to have an upper hand in courts because they have less tools. And on the other hand, I was wondering whether and how comfortable you would feel with disagreeing with an AI based tool, which suggests you should keep somebody in jail, or you should free somebody, or that you should go for a certain decision. But AI has a reputation of being neutral, as you said. And so that impose a burden on you before you come up and say, no, I disagree with the computer.
All right. So with respect to the first part of that question, just the inequities or inequality between litigants. I mean, I think that is true, certainly. I guess what is supposed to protect against that is the contingent fee system in civil litigation, right? So if, generally speaking, people without money can get a lawyer because they're going to give the lawyer a contingent fee, a percentage of the victory if they win. And there are a lot of federal statutes that also have fee shifting. So if you bring a civil rights case saying that you were wrongly arrested or that excessive force was used, you may not have any money, you can't afford an attorney. But if you have a decent case, you talk to an attorney, that attorney will take the case, because if you win your case, the attorney will get paid by the defendant by a result of the law, which requires the loser to pay in that context. So I think that will probably extend to AI as well, when there are applications that are deemed useful. In terms of, I think what's very important, at least with respect, what I use AI for is mostly research, Westlaw. AI is informing the research that I and my law clerks do. I don't see much downside to that. I think it has basically enabled me to have more confidence that I've captured the relevant case law and that I am better informed when I'm making a legal decision. If you look at since the advent of these types of systems, Westlaw and increasingly Westlaw aided by AI, what you find, I think, is that the decisions of judges have gotten better. I think that they are aware of the current state of the law in a way they wouldn't have been necessarily 50 years ago. And they are also able to explain themselves better because they have access to these other cases that might be distinguishable or not. So I think that's a good thing. And I don't think anybody would suggest that's a problem. I think with respect to bail tools, I don't think AI is usually, first of all, we're not really using AI yet with respect to risk assessment. It's really an algorithm, but it's an actuarial tool. And it's just predicting risk. It's just saying high risk, we think he's 90% likely to flee, as opposed to somebody else who might be 70% likely to flee. I don't think a judge confronted with those numbers, I think, is not going to feel like I have to agree. I think a judge might find them relevant and might put too much weight on it. And that's the reason why the judge, at least in the federal system, is not being told those numbers right now. Because there is concern perhaps that the judge will put too much weight on it. But the judicial officer, the pretrial services officer, is getting that number and is disagreeing about 25% of the time. I think that's probably a function of not having confidence in the actuarial tool. That they think that it is a blunt instrument and it's not accurate in this particular case. The case is distinguishable. I think as the AI gets more sophisticated, that might be a harder argument to make. And it might be that people are less willing to overrule. And the downside of overruling or erring on the side of release is that if something bad happens, a judge will be perhaps held accountable. Willie Horton was the famous story. I don't know if you remember this. Michael Dukakis, during the campaign in 1988, I guess it was, when he was governor of Massachusetts, he allowed a prisoner out on a furlough. He didn't do it, but he was the governor. And so he allowed a guy who had been convicted of a violent crime to get out on a furlough to visit family or to work or whatever it was. And while he was out, he committed a murder. And so that was used against Dukakis to show that he was soft on crime and clueless, and that he was pro-criminal. And it was very effective. And judges might be, concerned about getting it wrong and then being second-guessed very publicly. But I think if anybody has insulation in the process, it's probably judges, at least federal judges. I have life tenure. If I make a mistake and somebody commits another crime because I decided to take a chance on them, you know, it could be a bad day of news coverage, but it's not going to get me fired, and it's not going to get me impeached. And so I think probably judges are best situated to be able to make those independent calls. And since we want judges to be independent, I don't think you ever want to take them out of the process. You want them over the machine for virtually all decisions. I think that's where I would err, but I guess I'm less skeptical than some about the potential positive uses of it.
Thank you very much. Speaking about bail, I think we need to release you. I'll leave you to your work, back to your work. It has been an honor and a pleasure to have you, and I see colleagues here. You see two of them spoke, and Signorato is also here, and she's been silently listening to you. She teaches penal procedure, as does a colleague of ours who was connected to another device, and so you have attracted a lot of students and academics as well. Thank you so much. It was this has been a rewarding experience, also a personal privilege to me to have you.
Well, thank you, Andrea. It's a privilege for me. It's something I always look forward to. I think, I hope I didn't talk too fast. I'm a New Yorker, we do. I do think judges have an obligation to learn new technology and to learn new things, but also to get exposed to different arguments and different ideas. And I think settings like this are really important. I think judges really have to make the time to do it, because they will diminish their own unconscious biases by getting a broader perspective. So to be able to hear what Italian scholars think about things and what Italian lawyers and students think about things certainly is going to make me, I think, a more thoughtful judge going forward. I always say that to my students at Columbia that I teach. You know, they have the advantage of fresh eyes, and they get to educate me about things that I might not be sensitive to, because I've been doing this so long. I think I know it all. So this is a great opportunity, Andrea. I hope you'll continue to invite me to things like this and indulge me, and hopefully I'll learn more Italian next time.
This will be taken very seriously, and we will retaliate accordingly by inviting you time and again to our next events. Thank you so much. Just stick around while we say goodbye, so we can say goodbye to you properly. If you can just stay with us for 2 minutes while we shut down.
Thanks, everyone. Thanks, everyone, for taking the time out of your busy day. It was a pleasure.
Thank you very much to everyone. Goodbye.
Thank you.